Okay, well, we are at 6:01 now, so good evening, everybody. Thank you for joining me on this unseasonably warm April night. I am Tom Jose. I am the director of the Children's Law Clinic at the Center for the Rights of Abused Children. Um, so a little bit about us. We are a 501(c)(3) nonprofit that is dedicated to advancing, preserving, and defending the constitutional rights of children who have been abused or neglected. These are kids who are normally in or around the foster care system. We do this primarily through two ways. We have a policy side, which gets laws enacted in Arizona and in a few other states that help protect children's rights. We'll actually get into those a little bit later. So stuff like client-directed counsel for children is something that we've been working on in a few states. Getting state child protection agencies to stop taking kids' Social Security benefits when they come into care. That was one we did in Arizona, and we've gotten it passed in a few other states and sometimes by executive order as well. Then we have the legal side, which itself has kind of two parts. We have nationwide impact litigation. That's NAACP style, going state to state. Hey, finding where there are abuses, where are there things where children are not having their rights respected in different states, and meeting clients and working cases up so we can get state appellate courts and state supreme courts to respect children's rights and get those in published decisions. Then there's the other side, which is what I do, the Children's Law Clinic. We are completely Arizona based, and we more the meat and potatoes kind of stuff, is what I would say. Is we do things without a view of, are we going to be able to get a published decision on this? Are we going to be able to change precedent? We just do stuff where kids are falling through the cracks. So what I like to say is I find the kids who are falling through the cracks, and then I tell policy where those cracks are so they can patch them up. So that's just a little bit of what we are in a nutshell. So obviously, another part of this is doing training for people. I'm very much of the opinion that everything works better when people are more informed. Um, I've found it in my own life that my life is easier the more I know, and I think that applies to other people. So you can see on screen here is our um, our guiding example. So, and then I think that's to our new and improved website. So we actually just did get a new website. So if you want to use that QR code to go there, if you see any problems, I'll have my email later in the slides. Let us know, because we just went live with it earlier this week. So it's a very new website. If you see any problems, broken links, stuff like that, please let us know, and we will get them fixed. So a little bit of an overview here of what we're going.
Real quick, before you start, I'm just let everyone know if you have any questions, feel free to put them in the question and answer box or the chat, and I'll bring them up to Tom as we're going along. But we can't answer any case-specific questions you might have. If you have those at the very end of the presentation today, there'll be a link to our intake form, and you can put any case-specific questions there. But for more general questions you have, please put them in the chat or the question and answer box, and we'll sprinkle them throughout this presentation.
Yeah, thank you for that. And just so everybody knows, I can't see you, unfortunately. It would be very nice, but all I'm seeing is my own PowerPoint. So please, if you have anything, yeah, you do have to put in that question box, and Logan has to let me know. Because from my point of view, this is just me essentially staring at a wall, speaking to myself. Um, so we're going over these five areas: dependency, the overall process, confidentiality, what your responsibility is in that regard, legal rights, both of foster children and of foster parents. And then at the end, a little bit of miscellaneous. And like I said before, some of the new laws, some of the newer stuff. So most of the stuff you're going to see in the first three parts, if you've taken trainings with me before, you might recognize some of this, and then the miscellaneous and the new stuff will still be new and still be worthwhile to you. And you will still get foster care credit even if you've seen parts of this before. So please don't leave. That's all. That's what I'm trying to say. All right, so let's start at the beginning. It's always a nice place. I don't want to drop you in the middle of the dependency process and then go 6 months earlier. It's like a flashback to the beginning of the story. So it's a lawsuit, and it's a lawsuit that alleges that a child has been abused, neglected, or abandoned, and that the child is dependent on the state. And that's where dependency comes from. And what a dependent child is They do not depend on their biological parents. They depend on the state. Um, and it's filed usually by DCS, usually by the state, but others may file. There is such thing as private dependencies and private severance actions. But usually most of these are going to involve DCS, and usually when DCS is the filer, there's a slightly different set of rules. Usually it's the same rules, but with other things added on because obviously the state has more resources than private parties do. And when it's initially filed, that's like anything else, is any other court action where it's somebody's just alleging this is what's going on, right? And that's something that has to be determined by a court, and parents are able to get a trial. So this looks very complicated. This takes essentially the entire Arizona process from start to finish, and usually this takes, a year and a half to 2 years or much longer, depending if we go all the way through things. Um, so if we, do I have a pointer on this? Maybe not.
I
Oh,
feel like I saw it for a second. Oh, I do see it. Oh,
oh, oh, can you
yes.
see this? Okay.
Yeah.
So DCS gets a report. That's going to be something called into the hotline. Um, Before they call it an investigation or anything, they have like I forget what the term is, but they get a report, they call it that, and if facially the report seems like it's alleging abuse or neglect, they're going to go to an investigation. An investigation can result in in-home intervention. That's unfortunately rarer. We don't see as many of those as we do dependencies. It's a tool that I don't think DCS uses enough of. What we do normally see is then we get removal of a child. That's going to be a court authorized removal. That DCS says, hey, can we remove this kid? Court says yes. And then within 72 hours of the removal, DCS has to file a dependency petition. Then we go to the PP5 or PPH, called the PP5 because it has to occur within 5 days after the petition is filed. This is stuff like, making sure that people get appointed counsel, like the kid and the parents get appointed counsel. That there's placement, that services are going to be put in place. um, After that, we go to the initial dependency hearing. And if there is in a private severance, we essentially start with this initial dependency hearing. That's going to be 21 days from the service of the petition. So if DCS is involved and the parents fail to appear at the preliminary protective hearing, then we go to initial dependency hearing, or if it's private, that's just kind of where we start. Um, and then all of these are going to be in service of trying to get to this trial adjudication here. So might be settlement conference or a mediation. Some people claim that there's a big difference between those two things. I don't think so. I think really the only difference is settlement conference, you're in front of a judge, and a mediation is you're not in front of a judge. Even in a settlement conference in front of the judge doesn't really make any orders based on it. Either settlement or mediation is all going to be by the parties what they agree to do, right? If they still disagree, well, that's what trials are for. Usually those are, especially DCS cases, about making sure that the services are in place, and that the parents are actually getting good services, right? So, say DCS was alleging drug use and they haven't put drug testing in yet, or they haven't referred the parent out to Teros for substance abuse services. At the settlement conference or mediation, that's going to be a good time to work on that and make sure, okay, DCS, we put the referrals in for Teros, blah, blah, blah. Pre-trial conference is really just making sure that all our ducks in a row for the trial. And then the trial adjudication, this is still just going to be on the dependency, whether the child is dependent as to the parent. Most of the time, if you have a dependency adjudication against a parent, they will then be put on the central registry. If it's for any kind of abuse or neglect, they will go on the central registry for that. And the disposition is essentially just the order coming out of the trial. After that, we come into this kind of long holding pattern, it kind of feels like, of review hearings. Um, Also known as R&R, report and review, has to be at least every 6 months. In practice, they're usually about every 3 months. Can be less, can be more, just depends on what the judge had for lunch. DCS is supposed to write a report in advance of the review hearing. That's why the first R in R&R. And then after 12 months after removal, we'll get to the permanency hearing. Usually the first ones, you're almost always going to stay with reunification. There are circumstances where, if the parent's just doing absolutely nothing, maybe we'll go to severance or something else then. Um, but usually for at least the first year and a half, most cases stay in reunification for at least until the 18 month, and a lot of them up to 2 years as well. But we see at the permanency hearing a couple different options here. So reunification, APLA, which is another pre-planned living arrangement, I believe. Essentially, it's most often associated with aging out. There might be something where they're living with other family members, or it's an older kid who doesn't want to go to severance but can't be reunified, stuff like that. It's a little bit rare. Definitely reunification, TPR, and guardianship are big three ways that we end cases. And then we see that below is motion for TPR or guardianship. And these will really move similarly. If the parent contests, then we go to an initial hearing and then a trial. If the parent does not want to contest or wants to agree, then that's something that gets kind of much more quickly done without having to go to trial. And then obviously the big difference being that if there is termination after that, there's an adoption case that's filed, and we go to adoption. Whereas guardianships are supposed to have yearly hearings after the initial entry. Most of the time, nobody goes to them. A lot of them are non-appearance hearings, where DCS might file a report and the judge says, okay, everything's looking good with the guardianship, and enters a minute entry saying that. So a lot of times, even when you get the guardianship, there is supposed to be ongoing stuff, but it's not usually very onerous. All right, so parties. DCS, who is represented by the Assistant Attorney General. Parents, who are represented usually by appointed counsel. The child and the child's attorney. And sometimes the child will get a GAL, sometimes parents will get a GAL. Um, they're I say this with love since I used to be an AG. There are some AGs who might need a GAL. But a GAL, and let's talk a little bit about what a GAL is. It stands for guardian ad litem, which means guardian essentially for this thing. And in Arizona, they are all licensed attorneys. But the biggest difference in practice between a child's attorney and a GAL is the child's attorney is client directed, meaning that the attorney does what the child asks for. And the GAL essentially works for the court, telling the court what the GAL believes is in the child's best interests. So you can look at it like kid's attorney is client directed and a GAL is essentially a best interest attorney. Um, and that's why we used to, up until goodness, 2019, 2020, children were routinely given GALs, and that was one of the laws that the center got changed, is to get them client directed counsel. Um, a question that usually pops up is, well, what about babies? And that goes into a concept of substituted judgment. So when a child is too young or too immature to direct the attorney to do something, the attorney has to look at it and say, okay, well, how much wood would a woodchuck chuck if a woodchuck could chuck wood, right? They look at the kid, meet everyone who's around the kid, and say, here's what I think this kid would want, if he could tell me what he wanted. It's gets complicated. Not really what we're talking about today, but it is something that I think foster parents should know what the difference is when you're talking to an attorney versus a GAL. And it also can explain why some attorneys do things that foster parents don't really understand or don't agree with. And that again has to go to the confidentiality of what the kid is telling their attorney that they want the attorney to do. And it may not necessarily be what, the foster parent or other people agree with or want. Um, the way I look at it, the way I explain it is, if you're looking at say a divorce attorney, a woman got battered by her husband, comes to a divorce attorney, says, I want you to file for this divorce. Attorney says, okay, does it, and then she reconciles with her abuser, comes back to that divorce lawyer and says, no, I want you to pull that divorce filing now, a client-directed attorney has to go and pull that, even though it might not be in her best interests and it might not be good for her. And that's not the attorney's role. The attorney is to accomplish what she's trying to accomplish. So when she says, pull that divorce petition, the attorney has to. Whereas a GAL would not have to do that. A GAL can go, no, you need to get away from this dude. So I think that usually kind of illustrates what the real difference is there is, client directed versus best interests. So
We have a question.
yeah,
So the question is, what happens if the parent doesn't contest the termination? Kind of going back to the last slide.
yeah. They'll come in and they'll have to do what's called a colloquy with the court, and the court essentially, um, it's a lot like entering a guilty plea, in a criminal case, right? Is they come in and the court says, "Hey, this is voluntary. You haven't had any drugs or alcohol this morning, and you want to not contest." Um, and usually they'll go through a little what some people call a drive-by hearing. Is they'll DCS will still put its evidence in, and they'll put the case manager on the stand. Hey, is this allegation in the petition true? Yes, it is. They'll get the testimony, and then the court will terminate rights. So that's something that can be done in termination, a guardianship, or more commonly in dependencies. A lot of times it'll be something where they'll work something out where DCS will get some more services in place if the parent admits the dependency. Um, so you still do have to go into court, and you're still going to have a court order afterwards. It's just not going to be an all day or 2 or 3 or 4 day adversarial thing. It's usually in and done in about an hour instead of several days. So some other people that are going to be in the courtroom who are not parties, the judge, obviously, the case manager, and that's kind of an interesting little thing, is like the case manager represents DCS, but is not DCS. And we've seen this sometimes where, like, when the case manager disagrees with what her boss has told her to do, um, and they'll come in and they'll give testimony that's kind of cagey and half-hearted. But it's not often. Most of the time, the case manager really is DCS for practical considerations, but the actual person is not. CASAs will also be participants, and of course placements. And all these people have a right to come in and sit in on the hearing, sit in on the R&Rs. There's even a rule that placement are supposed to be notified of all the hearings. I know that doesn't always happen. But yeah, so those are some of the non-parties who are also going to be around. And the difference between parties and non-parties is essentially parties can do things like call witnesses, they can offer evidence, they can file motions, whereas participants cannot. Usually participants are limited to stuff like just being asked about the child. I mean, that's something that some judges do, is they'll intentionally at the end of the hearing be like, oh, placement, I'd like to hear from you and what's going on with the kid. Um, Not all do, but that's kind of where participants are limited is, they can say things most of the time, but they can't do things like give evidence or make motions or stuff like that. One motion you can as a participant do is a motion to intervene, which would give you party status. But those are discretionary. Most of the time, judges do not grant them. I've heard something where it's motions to intervene in juvenile cases, and I don't know where they got this number from. They were probably just pulling it from somewhere. But I think it was something like 15% are actually granted. And even in the center's work, I would say we're probably 50-50 in our motions to intervene that have been granted. So it's not something that's favored. So really, there is a lot more that parties can do than participants can. Oh, hey, so I already talked a little bit about this, so we'll save a little time there. Client directed, substituted judgment. They must meet with the child within 14 days of the PP5 and before every substantive hearing. So the child's attorney personally is supposed to meet with the child within 14 days of the PPH. And then after that, they can send social workers. But they should be hopefully at least sending a social worker before every R&R. Um, the new rules, because this is the new rule that's down here that came out. I mean, I'm calling them the new rules. They're like 5 years old now. But under the new rules, I don't think we've had any cases that really says what a substantive hearing is versus something else. Um, so if you get one of the children's attorneys, um, from one of the government agencies, they're usually pretty good. With getting social workers out there before R&Rs. If you get one of the uh, independent attorneys, the solo practitioners, it's really a crapshoot. We've heard of some never meeting their clients, but we've also on the other side heard of ones who, meet with the kid before every R&R. So it really is just a roll of the dice on that. And GAL. So yeah, again, best interest of the child has a duty to the court. And again, same rules as about meeting with the child, must do it personally, um, within 14 days after being appointed, and should be doing it or sending a social worker before every substantive hearing. But again, they do not represent the child, they represent the best interests. So that's a little bit about just the nuts and bolts of the dependency process. Um, and next, we're going to be talking about confidentiality, what you can and cannot say. And I want to start this off by saying the overarching rule: just don't post it on social media, okay? Just don't post it on social media. If you're thinking, hey, I should post it on social media, just don't. Come on. That's the rule of thumb. That's the easy rule, um, that you'll never get in trouble. Okay. So confidential, your information, which I think is a nice thing. Um, Photo or identifying information of the child is being in the system. Um, the child's records, court info, anything you hear in the courtroom, from somebody else of, oh, the parent is or is not doing this or that. The parent is, has dirty tests. Do not be telling people about that. That is DCS information. What's not confidential is DCS agency info and information approved through a media release. Which the second one is very rare. There's not usually stuff done through media. Um, Stuff that, though, your experiences with DCS is not confidential. So, if you say, hey, the case manager came to my house and, I don't know, said something rude to me, as long as you're not revealing the child's information, you know, like, oh, she called me a bad foster father. Like, okay, that's something that you can tell. That's not confidential. DCS might say it is. I know DCS and the AG's office have a very large definition, of what is confidential, um, just because they want to, you know, I don't know what they want to do, but they usually have very expansive definitions of what's confidential. But I don't agree with all of that. So things that are your story, your personal interaction with DCS, and the system, I think that's all fair game. That is not confidential. But obviously stuff about you doesn't have to be released to the father or to the bio parents, and it's the same thing of anything you hear about the bio parents through the court process. You should not be distributing to other people. That is going to be confidential.
Tom, we have a question on the GAL slide.
Yeah.
They said best interest of the child, not what they said to us. They said what the attorney feels what the child would want.
So that sounds like substituted judgment to me. Is what, if you are a client directed counsel, you're supposed to be trying to figure out or feel what the child would want. That's the substituted judgment. And GALs should not be doing that. Now, they may have, and that attorney may be laboring under a misunderstanding of what the differences are between things. That definitely happens. Maricopa County, when we changed the statute, getting kids client directed attorneys instead of GALs, Maricopa County made the decision to just unceremoniously flip all the GALs into client-directed attorneys in all their open cases. And that caused a lot of issues because it was just kind of an overnight. We were expecting a more gradual that, the current existing cases would kind of play their way out, and new cases, they would get assigned client-directed attorneys. For some reason, that was deemed by the courts in Maricopa to be too difficult, and so they just kind of flipped everybody overnight. And then for a long time, maybe 2 years afterwards, judges were routinely also appointing GALs in just about every case. So for a while after the transition, we had a lot of problems. Not a lot of people knew what was going on, and people were unsure about their roles. I hope that cleared it up a little bit. But that did sound like substituted judgment versus uh, a GAL's best interest model.
And we have another question from the confidentiality slide.
Yeah.
They said, is information that the child tells to the foster parent considered confidential?
Um, it certainly is not confidential from like DCS or their attorney, especially if it's something about any kind of ongoing abuse or even past abuse. Um, if it's something, I mean, if it's something where the kid is saying, mommy takes out her pipe and smokes it at unsupervised visits, again, I wouldn't go around telling third parties about it. I wouldn't go around, put on Instagram or anything like that. But you should definitely tell the case manager. And something that is a instance of abuse or neglect could also be, just reportable to the hotline as well. Um, so for the working within the system, no, you don't have to keep that confidential from the other system actors. Um, but depending on what it is, you might not want to be putting that other places, right? If it was something like, you know, um, inane and cute, you can send that to your parents, right? You can send that to your brothers and sisters, your support system, and be like, oh, look at what Timmy said. It was so cute. That doesn't have to be something locked down. But again, I wouldn't share it like really publicly. Um, and yeah, anything about abuse or neglect that is never going to be confidential from DCS or the child attorney. Those are things that you need to report to them. All right, legal rights. So we have federal laws, state laws, and local. Going down in that order. Most of the way that this works is like with a lot of other things, especially because really it is works a lot. State child protection works a lot like a benefits program. Is that we will have federal laws that essentially say if you want to draw down this federal money, you have to do the state, you have to do certain things. Um, and then the state will enact those laws, and those are then, enacted and acted on at the state level. And then there's some local stuff. Local is not usually doesn't give you much more than state law, but there's a little stuff. So the Foster Child Bill of Rights, not all of these things happen in every case, but I think it is important for foster parents to know because I think foster parents are usually the number one advocate of their foster children's rights. Um, so here's a few of them. We put the statute there, ARS 8539, so you can go see the full thing. It's about a page long and would really uh, take up a lot of slides and not be very nice to look at. But so contact info for their caseworker, for their attorney, and a right to speak with them in private, right? If you can't speak to an attorney in private, you don't really have a right to an attorney, in my opinion. That relationship requires confidentiality and candor. They can participate in service and permanency planning in an age appropriate manner. Obviously, a 16-year-old is going to have a lot more to say and have a lot more insight and input into their services and absolutely permanency planning than, say, a 1 year old. They do have a right to attend court hearings and to speak to the judge. This is one of the things that I see judges routinely get wrong is at every hearing, the child's attorney needs to be telling the judge if the child is not there, the child's attorney needs to tell the judge that and why. And if the child's attorney does not do that, the judge needs to ask, why is the child not here? And I almost never hear judges ask that. Um, children's attorneys are spotty at that at best, and I have never heard a judge actually ask, why is the child not here? And I think, I think a cultural thing of a lot of kids don't come, and I think a lot of attorneys and judges, I think, feel uncomfortable having kids in the courtroom. Obviously, that's not universal. I'm not saying that about everybody, but I think widespread culturally, there's this kind of this feeling amongst the actors in the court system that they almost prefer not having kids in the courtroom, um, which is wrong. I mean, we even see kids who are under 16, even under 12 who want to be there. Even if it's just, I'd say the biggest question I get asked by kids from, I don't know, 7 to 12 is, like, oh, do we get to go in person? And like, do we get to talk to the judge? Do we get to go in the courtroom? And like, they almost feel it's a cool thing, like this is their Law and Order moment that they actually get to be in a real courtroom. Um, and then they usually get disappointed when I'm like, no, it's just a Zoom call. And they're like, oh, okay. So a lot of kids do like the actual going in the courtroom. There are more rights for kids over 16. So if you have an older teen, go ahead and check those out. That's going to be stuff like getting documentation, like birth certificates, and stuff like that, identification, so that if they are aging out or whatever, however they're trying to get into adulthood, they have the tools to do that. So also information about things like extended foster care, independent living. The over 16s get all of that stuff as well. And full access to records for foster parents. And what full access means, we're not really sure. It has not been adjudicated. Um, but please go. You can get these if you just Google ARS 8539. It'll come up with the Arizona legislature's website is usually like the first Google search, and you can see the full thing. Foster parents.
Um,
Yeah.
Sorry, I'm going to interrupt you real quick. We have a question. Are foster parents' information confidential from bio parents?
Yes. Usually you have to ask. Um, so that is something. And actually, it's actually right on this line to have placement information kept confidential when necessary. Usually, it's something you have to go to the case manager and ask, but it is certainly something you can do because obviously, and not all bio parents are like this, but there are some bad people. There are some people who have done violent things, and we've had cases where bio parents have been uh, threatening, foster parents, the judge, the attorneys, whoever they can. So that is something where and I usually recommend only in a safety situation, right? There are a lot of times where, your placement's information doesn't have to be confidential. So, um, I usually advise foster parents, like, don't make it confidential until you see a need for it, you know? Um, and that could be at the outset of the case, right? If you have a case where, dad murdered the mom in cold blood, yeah, I mean, you'd probably have a reason not to not want that guy around you. I mean, he's probably going to be in jail anyway, but there certainly are some bad dudes that just on the nature of what they've done and how their kids got into the system, you may want to keep your information confidential. But for most of the run-of-the-mill parents who are, just neglecting kids because of drugs, usually that's not necessary. And a lot of times it can be good as a foster parent, good for the parent and the kid to have a relationship with them. But yes, you definitely have a right to have your information kept confidential. It's a couple of the other rights to be treated with consideration and respect and to be included as a valued member of the team. And whenever I give this in person, I always, after people stop laughing, I ask for them to raise their hands if they feel like those are rights that they've been afforded. And I have not had anybody raise their hand yet. Um, So these are technically rights you have. It'd be nice if people actually, you cared about them. Anyway, to receive support services, to be informed of all information regarding the child that will impact foster home. I know that is rarely done either. Contribute to the permanency plan. Ugh. Um, and one I've never seen foster parents actually try to do is this last one, is to be assisted in dealing with the loss and separation when a child leaves the home. I do not know what DCS has for that, but I also know that a lot of times when the child does leave the home, foster parents are not looking to DCS for consolation. So that would be an interesting one to me to find out how DCS really is dealing with that. To be informed of agency policies and procedures. Usually that's going to result in them sending you a link to their entire policy manual that's like 500 pages, and they're going, it's somewhere in there. Other times they might just make it up. Um, to receive training, hey, you're getting that right now. So I know that right's being respected. So congratulations. Uh, report a violation without fear of punishment or retaliation. Not be discriminated against. I don't see a lot of discrimination, to DCS's credit. And this last one is really spotty: to be notified if a child is returned to foster care or becomes available for adoption. We actually see this two different times. We see this here in the Foster Parents Bill of Rights, and we also see it under Jacob's Law as a completely separate thing. And yeah, it doesn't happen. Um, it may happen sometimes, but it should happen every single time, and it does not. It shockingly, there's a shocking amount of times it doesn't happen, or they just throw the kid back into another stranger's home, and it's like, why, DCS, why are you doing this? Like, um, so one of the notes I've heard about that is, if you think that one of your foster children is going to be returning to foster care from unification, keep up with your licensing worker, because they have access to a lot more information about the kids who are coming in and out of the system. Who's at the welcome center and stuff like that. So make sure your licensing worker knows about it, your licensing agency knows about that, and they can try and keep an eye on that. That's usually how we see those cases: is the licensing worker is like, oh, she came back into care, DCS didn't tell the foster parents, and then just placed the kid somewhere else. um, and if that happens, we usually try and get into the dependency, file motion to intervene to file change of physical custody. So um, yeah, for a long time, here we are. Yeah, for a long time, these they've been on the books for, I don't know, a couple decades, so as long as I've been practicing. But until like 2, 3 years ago, they all said at the end, these rights do not create any enforceable rights. And it was really silly that like you had these list of things that they're calling rights, and at the end, yeah, you can't actually enforce them though. So we got that changed a few years ago, because I mean, why even bother having the statutes if it's not enforceable? So for children who are in care, and for bio parents, because bio parents also have a list of a Bill of Rights, they're able to do that in the dependency. They can just walk straight into the dependency and say, DCS is violating my rights. Um, Foster parents, since they are not parties to the dependency, it's a little bit different. You can notify the court orally or in writing of, hey, you know, DCS is not treating me with respect and dignity. Um, or you can also go to the ombudsman's office with DCS, or the Ombudsman Citizens Aid, which is under the legislature. Um, and I guess I'll explain a little bit about that. So DCS has an ombudsman within DCS, and it's usually pretty hard to actually get them to do anything. The majority of the time they say, oh, there's no problem here, because they're within DCS, right? It's like, you know, police internal affairs, and they're going getting donuts later. The legislature's ombudsman citizens aid is different. It's in the legislative branch, not the executive like DCS, and it's different. They'll listen to you, but as far as getting anything done, now we're talking about the legislative process, and since they are in a different branch, they can't really just straight up tell DCS what to do. So there's, I don't know, upsides and downsides either way, but you should know that those are two different things, and you can file a complaint with either of them.
Tom, we have a great question.
Yeah.
What are some of the contributing factors for DCS not alerting former foster parents that the child has been put back into the system?
So by statute, DCS is allowed um, to not inform the foster parents for things like if they have an open investigation, if they've had substantiated allegation, stuff like that. Then there's all a catch-all, I think, for just if it's not in the children's best interests. Um, Most of the time, it is just carelessness and complacency from DCS. Is they don't stop and go to Guardian and say, "Oh, this kid was in care with these people. Let's give them a call." They just go, "Oh, throw them over at the Welcome Center and call the next agency on the list to find a placement." Um, Other things that I've seen um, is a case manager who does not like the former placement. I've definitely seen that. Of course, they're never going to admit it, but it is the truth. If you have a caseworker who, for whatever reason, bristled with the foster placement previously, when the kid comes back into care, they're going to take that as like, okay, now I can get rid of these foster parents and work with somebody else. Other things might be stuff like geography. So I've seen cases before where the kid had been taken into care in Tucson and placed with foster parents in Phoenix because they didn't have anybody in Tucson. And then on the second time the kid came back into care, they placed him in the area around the parents in the Tucson area. And they were like, well, obviously face-to-face visitation is going to be best. So that's why we did that, so that the child could continue to visit more easily with the parents. That one I think is arguable, but I think it's definitely the biggest one is just complacency by the department.
And going along with that, Tom, does DCS call families for replacement if they've moved out of the state?
The law says that they have to alert them. Um, I've never had that come up, but the law does not. It just says shall notify, something like that. So that's a very excellent question. I don't know offhand, but my gut is telling me that because it's not like an immediate placement. They have to, inform them, right? And they should be placing. But obviously, if you have foster parents in another state, they're not going to be available for immediate placement, because you'd have to do an ICPC packet. Um, but I would like to hope that DCS should be calling them saying, "Hey, this kid came back into care. Did you want to start an ICPC?" Um, that would be my hope, but I've never had a case where that's come up, so I can't say for sure. And back to Jacob's Law. Placement packet, you should be getting it immediately. You should have your caseworker contact information, access customer service line, list of providers, and the regional behavioral health authority contact. And this is in case DCS somehow forgets to tell you that the child might have behavioral and mental issues that show up immediately and are drastic and severe, so that you're able to have that information for access and the RBHAs to get that child mental health services immediately. That's going to be the point of that, and it should be in the placement packet. Oh, there we go. She's an urgent need for behavioral health services. Can you go directly to the regional behavioral health authority? I think they have to get the evaluation done in 72 hours, and then the first appointment for treatment should be 21 days after the evaluation. Records. Um, and if anybody wants this PowerPoint, we can send it to them. We should probably change that. That's a link. That should probably be a QR code. Um, I'll remember that in the future. I probably won't, but I'll try. So you should be able to get records if you're a prospective adoptive parent, foster parent, a guardian, um, and anything that's reasonably necessary to promote the child's safety, permanency, and well-being. I also have not really seen this being used. I've seen I've seen case managers give lip service to it of, oh yeah, I'll get that to you. Oh yeah, I'll look for it. And then somehow they forget. Or this is all I found on Guardian and it's like almost nothing or something like that. So, um, if anybody has experience with it, I'd love to talk to you sometime and see what it is. But you should know this is here. This is something you can, and I think should request. Um, and I think it also sets a tone with case manager, like, hey, I care and I want to see records and all that fun stuff. Going back to dependency petitions, like I said before, any interested party. So that could be a family member, that could be we file them on behalf of the child themselves. Could be DCS, could be a teacher. Um, as long as you can legitimately say you have an interest in this child's welfare and well-being. So removal. Um, they are entitled to notice if the child is being moved to another licensed foster care placement, and you can request a conference within 24 hours. If the child is being removed from your care because they're going back to the parents, you don't really get a say in that. Most of the time, that's going to be the court ordering that. So obviously, you don't get a say in that. Um, and I mean, most of the time when I've seen these has been if DCS is proposing to substantiate an allegation or something like that, and then they say we're just pulling all the kids out. So I've only really seen this being used in bad situations. Um, but that's not to say that they're all like that. It could be again a case manager just not liking you. I've also seen situations where DCS has removed kids essentially because the current foster placement refused to do a guardianship. Where the foster placement said, no, we want to go to severance and adoption. And DCS said, okay, well, we're going to remove the kids and put them in a placement that will do a guardianship. So, um, also not a fun time. And usually that conference isn't going to get you very far. Usually, if it's one of those situations, you're going to want to try and get involved in court. But yeah, this is available to you. Right to be heard. Um, So you should get notice of all proceedings and you have a right to be heard. That does not include being appointed an attorney, but you do have a right to have an attorney. So in the clinic, we routinely represent foster parents and just make sure that their voices are heard. It is also something where, you're at the end of the R&R and they're kind of wrapping things up. And if nobody's heard you go, Your Honor, I'd like to say something as a foster placement. And almost all judges will say, okay, yeah, go ahead. Some judges are even nice enough to come around and ask and make sure that you're heard. And yeah, so not much more on that. As I said earlier, foster placement may file a motion to intervene. It is not as of right. It's just something under the rules. And under the rules, they have a few different, guides for helping the judge make the decision. Most of the time, where these are denied is because the judge will find that you're not really adding anything. Is that your position, will be adequately advocated for by, the child's attorney, child's GAL, or DCS. Um, but not always, actually, what I was working on today, representing a foster parent where we had our motion to intervene was granted, and I was actually right at closing arguments because we participated fully in the trial and everything. So you are sometimes able to intervene. I'd say the where your courts are most likely to grant it is going to be something like if somebody other than the parents files a change in physical custody, like aunt or an uncle or grandparent comes in late into the case, and they move to intervene to file a CPC. Usually, the judges will let the foster parents who the child's going to be taken from also intervene, and then those two interveners can kind of hash it out. Anybody can file for severance. This is a severance petition, um, so you can go straight to severance. Without doing the dependency. So when you're already in a dependency and the court changes the case plan, it's called a motion for severance, and that can only be filed by parties to dependency. If you file just a completely separate severance petition, however, that creates a new case that's going straight to adjudicate whether the parent's rights should be severed. And any person that has a legitimate interest, including relative, foster parent, physician, um, or even the agencies. Here are some forms. There's another thing we should probably change to court hearings, open to the public. I know they might not seem like it, um, but technically they are open, and there are specific rules for closing them, and it's essentially that it has to be in the child's best interest to close them. So you might see some things like sometimes the Republic will do a thing where they go, "Oh, I went and just sat in on, child protection cases for a day." Like that's allowed. You can just walk in to the court and just sit down in a courtroom and start watching. It's definitely a lot harder now that like all the R&Rs in the morning are over, Teams or Zoom or whatever. Um, but even then, if you want to be in person, we have had judges who say, yeah, I'm not going to be there and none of the other parties are going to be there. But if you want to go and sit in an empty courtroom and, still participate on Zoom, feel free. You are entitled to notice and an opportunity to be heard. Yeah, see, just like this. And also, remember, going back to the confidentiality as well, that's all going to be subject to the admonition. So, like I was saying before, if you can sit in a hearing and hear, oh, this guy, smoked a bunch of meth and then hit his kids. Yeah, you can go and you can sit there and you can listen to it. You're not allowed to walk out and say, hey, everybody, I just heard this guy smoked a bunch of meth and hit his kids. That's not allowed. So you are allowed in, and you are allowed to observe, but you cannot take what you're hearing at those hearings outside and go abscond with it. So if you look at these things, they always redact any personally identifiable information when they send people over. Miscellaneous. How can you advocate for children? Participate, speak up at court, take notes. Um, Notes are always very good. I've seen a lot of children's attorneys when we're getting ready for trial, they want to see foster parents' notes of, oh, did you guys take notes of every time parent missed a visit? That's very big for like 15 months time in care and stuff like that. Um, know the supervisor in the chain of command. If you are having a problem with your caseworker, you can take that up. Um, and again, the ombudsman and the ombudsman citizens aid that we already talked about, and eventually try and hire an attorney, file motion to intervene, stuff like that. But the biggest way that you can advocate is going to be participate. Um, go to the CFTs, take notes, make sure that you have good notes for everything you're doing. Those are going to be the biggest things because those are also going to be the base from which any of the later things, like going up the chain of command or getting an attorney, we're going to want to see those things as well. If it isn't in writing, it did not happen. Um, do not let case managers bully you into, I'll just call you and we'll talk about it over the phone. Please don't do that. Email. And if you have to email them, remember they are very busy. Keep it brief, keep it relevant. Don't rehash, the factual basis of how the kid came into dependency of, I can't believe this is happening because of look at all this stuff this parent did in the past. No. What is happening today that they need help with, right? What is happening today at visits? And then who to send it to. Usually that's going to start with the case manager. If you have their supervisor, loop them in. But yeah, in writing, brief, relevant. Right to be heard. I think we've talked about all this before. Um, Claiming on taxes, which I have a little over 5 hours left to do mine. Um, a lot of times bio parents will continue to claim their children on their taxes. Do not be surprised when that happens. You are allowed to do it as the foster parent. I'm not sure if the rule is 6 months or whatever, but um, the IRS doesn't care. It's the same thing with divorced parents who split custody. It is first come, first serve. The IRS does not care who's claiming them. Mandatory reporting, obviously, if the kid comes home with a black eye from an unsupervised visit, you got to report that. I think we talked a little bit about that in the earlier. Haircuts that significantly alter appearance. This doesn't come up too often. It comes up mostly with the ICWA kids, with tribes that really have a lot of pride in having very long hair. Um, so, be wary of that. Sometimes kids will come in with dreadlocks that are also very hard to regrow. So if we're talking things that significantly alter an appearance, don't, if a kid is Navajo and has hair halfway down his back, don't take him in for a buzz cut. Just get those split ends cut off and keep his hair the same. All right, a little bit about new laws. The two biggest ones that I think are going to impact foster parent the most, immediate bid meetings and federal benefit protection. So bid meetings are best interest determination meetings, and that comes to us from education law. And so whenever a child is brought into care or changes placement while in care, within 5 days of that change, the child's old school, proposed new school, um, foster parents and DCS all have to get together and have a bid meeting and ensure, like, does he stay at his old school? Does that have, what are the advantages of his old school? What's going to be the issue of transportation? Is this new school going to be able to handle it? How are we going to get records over? That's another part of that law is that schools have to enroll foster children without regard to having any of the paperwork. They have to immediately enroll them and then figure the paperwork out later because that was a big problem. So if you're not getting bid meetings in 5 days, or if the new school is trying to box you out and say they need a bunch of paperwork, go fill out our form and we'll go knock some heads. Federal benefit protection. So if a child has Social Security, SSI, it used to be DCS would take that money and put it into its general fund, and then the kid would get none of it. We got that changed. They're now going into individual accounts in the child's name. Um, we have had some fights on uh, who should be the one who's controlling that under Social Security law. There's also been some things with the Social Security office of not releasing it. Again, that's something that you should be able to get, the fiduciary, whoever's in control of it, to do stuff outside of what DCS is supposed to be doing. So summer camps or stuff like that. If you're seeing issues with that, again, let us know. We can definitely help with that. But the state should be making these accounts, and they've been pretty good so far about making these accounts for kids so that they can keep that money and then use it when they're old enough. I think this is just about the end before we get to the quiz. So relative search. This is something I think is important for foster parents to ask the case manager, like at the very beginning. So DCS, within 30 days of the child being removed, is supposed to start a search for relatives, and it's supposed to be an ongoing search if they can't find anybody. Too oftentimes, way too oftentimes, we've seen cases where the kid is in care, in this foster care for a year, 2 years, 3 years, with the same foster parents, and then oh, we changed the case plan to severance and adoption, and then in flies this grandpa out of nowhere, in flies this auntie out of nowhere, who's never met the kid, and they go, well, when the kid was just in foster care, I didn't want to get involved, but now, that it's going to be adoption, now I want to adopt him. We've all seen probably more where DCS just doesn't do its job and doesn't look hard enough because, oh, we put him in a foster placement, he's fine, we don't really need to look for kinship. So this is something I think to establish early with the case manager of like, hey, I know you guys are supposed to be looking for kinship within 30 days. How's that going? Have you found anybody yet? um and that puts it back on them that they know they're supposed to be doing that because those are the worst things where you have family who might have been boxed out or something like that, and trying to balance blood versus love. Those are hard cases and we don't want to deal with them, so it's better find the kinship early, get the kid placed in kin early. And foster parents do become kin. They have a significant relationship. So if the child is under 3 years old and has been in placement for 9 months, you are officially considered kin. Couple new things. I think a lot of these were in here. Okay. And Here is a QR code for this. I believe I was told that you will get an email tomorrow that will have the link to the quiz for continuing education credit. But it is now 7:01 even. I've gone a minute over. I'm sorry. So this is over. Feel free if you still have questions. You don't have to stay here. You've done everything for foster care credit. And if you have questions, feel free to stay around. Like I said, all I have is to do with my taxes, and I'm really not looking forward to that. So I've got some time to sit around and answer questions that people have.
And I put in the chat the link to get credit. So I would go ahead and click that if you can. And then I think once you end the seminar, it'll give you the link as well. Either way, if you don't get the link, feel free to email Tom at the centerforchildren.org, but it's also in the chat. So yeah, thank you for coming, everyone.